That's good. We're back on the record. The time is 36 minutes after the hour of 2 o'clock. Still on the same date. Again, Thursday the 20th. This is the third day of the actual trial, fourth day with jury selections. The jury is not present. They've been sent home for the day. We have run out of witnesses available for the day, but we still have one motion to be argued. There was a motion made by the defense with regard to Rule 52, an admin rule that has to do with having a witness by something other than personal. Again, a remote, a reliable electronic means witness for a trial. This defense made the motion. The state has objected. I believe they objected for, first off, that the timing was incorrect. There wasn't sufficient time given. It was the wrong rule, perhaps, and that the guarantees weren't assessed sufficient for allowing it. I think that's where we're at, and I don't remember which one, but one of the parties wanted to have a hearing. So this is our hearing. Mr. Sand, are you prepared to go forward with the argument on your motion?
Yes, Your Honor.
And thank you. I apologize, William. And the state, Mr. Nelson, are you prepared to go forward with the argument?
We are, Your Honor, but I would like to point out no one actually requested a hearing. It was requested that there was some statement about reserving the right to argue something, but at no point did either party request a hearing on the motion.
So we're done?
From the state's perspective, yes.
Okay. Well, I'm easy. I thought for sure somebody had requested it, and that's why I've been putting it off for a while.
It was never requested by either
Well,
writer.
Your Honor, if I can look.
Under 3.2, a party wanting a hearing is required to request a hearing, and that was not requested. So
I guess on page 3 of defendant's reply, we did request to go on the record before the court for oral argument.
Okay. That's maybe the part I remembered. Okay. I'm not going to go check it. I'll take you at your word, Mr. Sand. Well, that having been said, then we now have argument. So, Mr. Sand, do you wish to proceed with argument on the motion?
Yes, Your Honor, and I'll be very brief. I think that the defense laid out its arguments. There's quite a lot of briefing in this. I think there were 5 briefs submitted, 3 by the defense. It pretty much comes down to the fact that we have tried to exhaust so many potential remedies, reasonable remedies, to get Mr. Hall here in person. We have subpoenas at the tribal court in Fort Peck. We have the opportunity, or we have put forth to the court the option to have a court reporter who has actually been a court reporter in many of the depositions in this case to go out to Fort Peck and assist to make sure that Rule 52 is complied with. I believe it's Rule 52, Section 2G, regarding the electronic transmission of documents and such. And the main basis for our argument is for Rule 52 in Section 4 for criminal action. All of the exceptions in Section 4B pertain to a defendant. It is specifically for a defendant's right, the right to waive the person to be there, the witness to be there in person so that they can confront their accuser. Number 2, number 3, number 1, number 2, number 3, all specifically address a defendant's right. I believe we laid out in one of our briefs that we originally had made contact with the Fort Peck Adult Correctional Facility. They had given us assurances that they were going to be able to transport, and then the following day they told us, or following days they told us that they rescinded that promise. We brought this motion very briefly at the expedited status conference that we have. Your Honor had asked that we file documentation with that, and we did file an exhibit. It was an email chain between members of our staff, or an attorney at our office, and the Fort Peck Correctional Facility. All of those factors and all those considerations being taken into account, plus the fact with how much, I mean, it's interesting that this hearing is happening during this trial with how much Mr. Hall has been brought up. The fact that he is in the defense's position, a strong suspect. I believe there has been testimony by state's witnesses that he was a suspect. It's extremely important that he is available to testify here because of the fact that he's in Fort Peck. It makes it very clunky for the defense to get him here. So we think that the most reliable means he's in Fort Peck, he's in jail, he's been deposed there before. We can have a court reporter who's been at one of those depositions before, who's familiar with the facilities there. We believe that we have laid forth enough grounds to meet all the requirements of Rule 52, Your Honor.
All right, thank you very much. Mr. Nelson.
Your Honor, I'm going to reiterate some of the things that I put in my response, that there's been a lot of bad faith arguments from the part of Sand Law on this. First of all, I will agree the documents that they showed were that Mr. Hall was subpoenaed by them way back in January. They submitted those. I have no reason to believe that those are incorrect. Sand Law waited until March 7th, which is a Friday, a couple weeks ago, to contact that Fort Peck about transporting Mr. Hall. That same day, and I know this because I personally called the same person that was involved in that email chain that they referenced, called the Sand Law and told them that due to some issues with manpower, that they were not going to be available to transport Mr. Hall. So it was the same day that that conversation took place. I was also told by that same individual that there were no emails prior to the creation of that email chain after that hearing that we had on the 12th, which is why the dates and the timestamps on those emails are all after that time frame. In court, they had mentioned an email. That is false. There were no emails prior to that point. I would also point out that in the original motion, they failed to follow the rule, which is very clearly laid out on the policy, the procedures that you're supposed to follow. There's also a part in there about the timing, that it has to be done at least a week in advance, and that was not done at least a week in advance. They did not reach out to the state, and we are in this position because they waited until the 11th hour when the rule says that things have to be done in a certain period of time. They are arguing in bad faith. They did not follow the rule, and the state is requesting that the court deny their ability to have Mr. Hall appear by reliable electronic means, that he must appear in person. We've also had testimony, very clear testimony. He never rose to the level of a suspect. He was a person of interest, and that the evidence showed that he wasn't even in Minot, North Dakota. He wasn't even in North Dakota at all at the time of the murder. So, and the other point, Mr. Sand was talking about the defendant's right to face her accuser. Mr. Hall is not accusing the defendant of anything. So that part of the argument is meaningless. So that's the state's position, Your Honor.
All right. Thank you very much, Mr. Nelson. Couple things. I had previously asked the defense counsel to supply the information, and I believe they have with regard to the exhibits of the emails. Something that shows that Montana could not get the gentleman here. The other aspect of that was, again, my reading of Rule 52 is slanted heavily in favor of the defendant's constitutional rights with regard to being able to have witnesses appear in person as opposed to some other means. The defense counsel submitted a statement that is allegedly signed by Ms. Rice, saying that she's in agreement to allow for this witness to appear by reliable electronic means as opposed to face-to-face in the jury or in the trial itself with the jury present. The signature on that statement, however, had no, I guess the term would be attestation with regard to it was a notary or anything that says it's her signature. I'm not here to question anybody's signature based on my own signature, that's for sure. So I don't know if it's her or not. So this is my caveat. I am in agreement to allow Mr. Hall to appear by reliable electronic means. All of the burden of making that happen is on the defense counsel as far as electronics, availability of both you and the state to show him exhibits and him availability to respond to those exhibits. Again, not just yours, but the state's also. And then the last caveat is I am going to require Ms. Rice to take the stand, raise her hand, and swear an oath that she's in agreement with this gentleman's appearance by reliable electronic means. That would be the only question. It would be given to her by the court. And if she's in agreement with that, then I have it on the record.
And that would occur during...
Right now.
Right now.
Mr., do you wish to talk about it? I'm just asking because, again, this is unusual, but I've never had this request before, so this is my cover all the bases.
No, Ms. Rice is indicating...
Ms. Rice, do you understand what I'm going to be asking you? Yep. All right, then I'll just have you stand up. Pull one of the mics.
Sure, I got you.
Have you raise your right hand. You swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes, Your Honor.
All right, you have a seat again, ma'am. My only question to you is that, are you in agreement, waiving any rights that you may have constitutionally with regard to this witness testifying not in person at your trial, but will be testifying by reliable electronic means?
Yeah, I don't have a problem with that.
And you are in agreement?
I'm in agreement.
All right. You're no longer considered under oath. Thank you very much. All right. Based upon that, the court will grant the defense's motion over the objections of the state.
Your Honor, the state does have a couple of requests in relation to that then.
Hang on. But again, I'm very clear on this as far as the electronics. All of it's your responsibility. All of the availability for reviewing documents, et cetera, is your responsibility. Okay, Mr. Nelson?
The state would request that the court require stand law provide, or the defendant, I should say, provide for the defendant to be wearing street clothes while he is, or not the defendant, excuse me, Mr. Hall, let me be very clear on this, provide for Mr. Hall to be wearing street clothes while he's testifying so that he's not wearing a prison uniform. The implication being that because he's wearing a prison uniform that he is guilty of something. I would also request that the court direct defense to not specifically identify the facility that he's in, because that also has the same inference to the jury that because he is currently housed in a correctional facility that he is somehow guilty of this crime.
Mr. Nelson, I appreciate both of those. Both of those seem to be very legitimate concerns. Again, I'm not sure how that plays out in my own head with regard to the reliable electronic means. We've been doing reliable electronic means quite consistently since COVID. All of my requirements for them, for that action, for using that, is that the people I have to know who they are, where they're calling from, and that they've agreed to do it, and that there's nobody else there that's participating in regard to that part of the case. Again, it's just general information usually. In this particular case, my guess is he will have to be identified. His location, I think, is going to be required.
It would be, yes, Your Honor. But the fact that that location, it could be limited to
city and state,
not the correctional institute where he's located in.
Okay. And as far as what he wears as far as clothing, I think that would be fine. I'm pretty sure the Fort Peck Reservation Correctional Center, whatever the title is, may probably have that flexibility that someone can wear civilian clothing. We just don't know if he has it, I presume. Maybe they do, but off the top of my head, that would be a concern as to what he actually would show up in.
If I may respond, Your Honor?
You may.
As far as doing our best to make sure that he's, it's not stated that he's not located in jail, I think that's something that we can try to get done as far as not being in prison clothes or in jail clothes. I know so many times during state court hearings I've had, the court says that they're not in charge of DOCR, they're not in charge of the jail. I don't know how the heck I could control that.
You cannot, Mr. Sand, and I appreciate that, and that kind of is what I was trying to say. To bring them to court, I can control it. But as far as what they wear inside their facility is a whole other deal. Very seldom do the courts try to interfere with how incarceration facilities run their facilities. We defer to their judgment based on their safety, their concerns, the priorities that they have with regard to their inmates, et cetera, and their staff, and so on. So we try very hard not to interfere or dictate. So accordingly, it would be nice if you can. Mr. Nelson, again, I'm not guaranteeing that, The only thing I could relate is that based on cross-examination, you may or may not wish to, again, not trying to second guess how you do your case, but you can always ask him why he's there and so on, which may be not a good question if you don't know the answer ahead of time. So we all know that that's not the way you do things. But
one more thing for the record, Your Honor, we can control, I believe, as much as we possibly can, in our line of questioning, the fact that he's not in jail, or tell the court reporter, say that he's in the town but not in the jail. I can't control if Mr. Hall says that he's locked up or.
That's true.
I just asked that it not be brought up by the defense, Your Honor. That's what the state is requesting.
No problem.
Okay, so that seems reasonable, Mr. Sand?
Yes, Your Honor. Thank you very much.
Okay, well then that will be the order of the court, that he can make his arrangements. Please, again, keep the state involved in your arrangements so that they're available and so forth.
Yes, Your Honor.
Oh, yeah, is this something I need to sign? Oh, okay, that sounds like a good plan, thank you. All right, any last thing, Mr. Sand?
No, that's it, Your Honor. Thank you.
Mr. Nelson?
I can't think of anything, Your Honor.
All right. Lonnie, was there an actual order in there for this or not? I think there was. Okay, I'll have to look at that. Maybe I want to change it. But here, Mr. Sand, I'll give you this, one of the Sand gentlemen. This is the information for contact information for the trial.
Thank you.
All right, then that will conclude our hearing then. Again, the time is 52 minutes after 2. We will reconvene tomorrow morning at 8:30. Is there anything else, Ms. Sorgan? Mr. Nelson?
Nothing from the state, Your Honor. See you then.
Mr. Sand and
No,
Mr.
Your Honor.
Sand. Anything else? Okay, thank you very much. That will conclude our day.